All right, you're Shane Rhodes appearing there from the jail?
Yeah.
All right, this is case number 23 CR 30, State of Ohio versus Shane Rhodes. This is a pre-trial being conducted by Zoom. Mr. Rhodes is appearing from the jail. Mr. Rhodes' attorney is Jacob Wagner, appearing from his office, and appearing from the prosecutor's office, Assistant Prosecutor King. Defendant's charged with breaking, entering, and theft. And I see that the discovery has been provided by the state, and you've received that, Mr. Wagner?
I have, sir.
All right. Well, your discovery will be due by the final pretrial. Do you anticipate any pretrial motions?
I don't at this point, Your Honor.
Okay.
Obviously, I'm going to file by the next pretrial.
All right. Has there been a written plea offer provided?
There has, sir.
All right. Is your client aware of that?
He's not, Your Honor. I'll be out to see him today.
All right. All right. Thank you.
Thanks, sir.
Do we have anybody else in jail?
Not for mine, Judge.
All right, this is case number 23 CR 13, State of Ohio versus Taryn Dwayne Deaton. You're Mr. Taryn Deaton appearing there on the screen. Mark Taryn Deaton.
Yeah. Yes, sir.
All right. This hearing is a pretrial hearing being conducted by Zoom. Mr. Deaton's attorney is Jacob Wagner, appearing from his office. Appearing from the prosecutor's office is Mr. King. Now, Mr. Deaton, are you all right there?
Yeah, the camera switched to a girl,
Yeah, okay.
so I thought it was somebody else.
All right. Well, Mr. Wagner, I think that you should put you and Mr. Deaton into a breakout room. I do have your plea offer here, and I have some concerns about Mr. Deaton because, according to what I received from the probation department, he was in the counseling center for about 2 months and left against advice on the 28th, and the reason that he left apparently was, as they said, he was relapsing on meth while he was there. I'm a little concerned about his state of mind right now. So I'm going to put you in a breakout room, let the two of you talk.
Yes, sir.
All right, we're back on record on State versus Deaton. The court suggested that Mr. Wagner talk with his client. Said the court has some concerns based upon the faxes I'm getting and some of the demeanor of the defendant prior to the hearing commencing. Mr. Wagner, what's your thoughts about proceeding today? I have some concerns.
I can say I did address that. I can't say that in my discussion that I thought there was any impairment. What I thought there was an attitude adjustment. There were other people in the room. I told him to get out of the room. I told him to conduct himself as if he was in front of you personally. So I think, not throwing my client under a bus, he needed to grasp the seriousness of the situation. Okay.
Well, what I'm going to do is I'm going to continue this hearing. It's going to be an in-person hearing. We'll set it for plea as well as bond revocation because one of the conditions of your bond, Mr. Deaton, was that if you were recommended to be in treatment, you were to enroll in and follow that during the pendency of this action. And based upon, you don't talk. Don't talk when I'm talking. All right? Do not do that, or I'll send the sheriff to get you today. Now, I just said don't talk. Now, anyway, so the hearing will be on the basis of set it for plea and bail revocation. So if the plea doesn't go forward, we'll still hear the issue of the bail revocation. Yes.
Your Honor, I had to move. They're not over there yet, but I was requesting the court for some of my sentencings on Wednesday morning, moving them to Thursday. Would that be an acceptable time of the court, Your Honor?
Well, it's going to be tough no matter when I do it, but we'll do it. What time are those? 8:30?
I've requested, if possible.
Yeah, Dallas Toll and Mount 8:30. All right, we'll set this for 8:30 Wednesday. Thursday, March the 9th. You're to appear in person at the courthouse, Mr. Deaton. If you fail to do that, there will be a warrant issued for you, and you'll be in more trouble than you are now. So, make sure you show up with the right attitude and try not to get high between now and then. All right. Anything further from counsel? I didn't ask for you. Counsel means attorneys. All right. You may sign off. Click on unmute down there in the corner.
Oh, yes, I'm sorry, Your Honor.
No, it wasn't your fault. I muted you because I was getting some background noise from you and the others, so I muted you. All right, this is case number 23 CR 35, State of Ohio versus Gavin S. Faulkner. Mr. Faulkner is appearing by Zoom on the screen marked Gavin Faulkner. His attorney is Jacob Wagner, appearing from his office. Appearing on behalf of the state's Assistant Prosecutor King. Defendant is charged with aggravated trafficking of methamphetamine in the vicinity of a school zone and aggravated possession of methamphetamine, second and third degree felonies. This is a first pretrial, final pretrial set for April 5, and a trial set for April 27. I see that the prosecutor did provide the discovery that was requested, and you've received that, Mr. Wagner?
I have, sir.
All right, and do you anticipate any pretrial motions?
I do not at this point, Your Honor, but if I do, I'll get them filed.
Okay. And your discovery will be due by then as well. Has there been a written plea offer provided?
It has, Your Honor.
And is your client aware of it?
Yeah, we spoke on the phone about the discovery in the case, Your Honor.
Okay. All right. Anything else then to discuss in this case?
No, sir.
All right. We'll see you then on your next pretrial, Mr. Faulkner. Thank you.
All right, thank you, Your Honor.
Thank you, Your Honor.
screen that's marked Lincoln Cam, you'll need to unmute yourself. Just down in the left-hand corner should be a microphone with a red thing through it. We need to send out an assignment notice for this guy here. This guy. Yeah. I set it for a bail revocation and a plea hearing 8:30 Thursday. He was high.
Oh.
There's a button down in your left-hand corner there, Miss Denowitz. It's got like a microphone and a slash through it. You need to click on that. Scroll down on your phone. Can't hear you. All right, we'll continue this to in person. You appear here at 8:30 Thursday morning. That'll be March the 9th, in person in the courthouse. All right, then we are back on record then. All right, case number 23 CR 14, State of Ohio versus Danielle Denowitz. Ms. Denowitz is appearing on the screen. It's marked Lincoln Cam, is that correct?
Yes, this is my son's.
Okay, I don't need explanation. I just want to confirm your identity, and so that the tape will understand who you are. The defendant's attorney is Jacob Wagner, appearing from his office, and appearing from prosecutor's office, Assistant Prosecutor King. The defendant is charged with illegal conveyance of drugs of abuse under the grounds of a specified governmental facility, aggravated possession of drugs, or of methamphetamine. This is a first pretrial. Final pretrial is the 22nd, and trial is the 10th. I see that the state's provided discovery, and you received that, Mr. Wagner?
I have, sir.
All right, and you anticipate any pre-trial motions?
Not at this point, I do not, Your Honor.
Okay. Well, it'll be due by final pretrial. And have you got a written plea offer?
Yes, sir, it's been relayed.
All right. All right. Now, Ms. Denowitz, I also have a fax from the probation department this morning that indicated that you were in a withdrawal management program and back in February and for one day and left, and then you were told to get evaluated. You claim you've been in contact with Brightview and Recovery Council. You haven't provided any proof of that yet. Condition of your bond is that if the probation department refers you for an evaluation and treatment is indicated, you're to enroll in and complete that or follow it during the case. So you need to get in touch with Mr. Arjima, and I don't know, where do you live?
I live in Chillicothe.
All right. Well, you need to get in touch with him and find a place. It shouldn't be that hard to get some place to evaluate you pretty quick. But it sounds like you may be a candidate. You've got 2 positive tests here on 221 and 228. So you need to be in treatment. If you're not in treatment in the next week or 10 days, and the probation department notifies me, I'll set a hearing to revoke your bond. Do you understand?
Yes, sir.
All right. Anything further from counsel? All right. Thank you. All right, this is case number 22, CR 129, State of Ohio versus Stephen Charles Weil. Miss,
Recording in progress.
all right, Mr. Weil is in the custody of the sheriff, is appearing by Zoom from the jail. His attorney is William Armentrout, appearing from his office, and appearing on behalf of the state is Assistant Prosecutor King. Now, this matter is set for a plea. Now, Mr. Armentrout, you and your client both agreed to his appearing by Zoom remotely rather than in-court appearance.
We do, Your Honor.
And you're all right with that, Mr. Weil?
Yes, sir.
All right. If during this hearing you need to talk to your attorney, since you're not sitting next to him in courtroom, you can just tell me and I can put the two of you into a breakout room where the two of you can talk to each other without anyone else seeing or hearing you, okay?
Okay.
All right, now Mr. Weil is charged with aggravated possession of methamphetamine, a third-degree felony. The matter is set for a trial. Let's see here. Well, I'm trying to find out where that is. I know there was a bond revocation. Oh, here, let's see. Well,
Your Honor, we don't have the trial attorney set.
okay, we had one and we vacated it when he was a no-show, I think. Okay, all right. So, I've been presented with a plea of guilty for Mr. Weil, which indicates that you're going to withdraw your not guilty plea to this charge and plead guilty. Now, I'll show the first page of it to you. It's got your name, case number, and says plea of guilty. You recognize that?
Yes, sir.
And it is 3 pages long. On page 3, about a quarter of the way down the page, there's a sentence that reads, and right below there is a line for signature of defendant, and I'll hold that up to the camera, and is that your signature there right below that sentence?
Yes, sir.
When did you... Wow.
I think it was like the 26th or 24th. Somewhere.
All right, last week?
Yes, sir.
Okay. Now, when you signed it, did you understand that it's an agreement to plead guilty, which means there's not going to be a trial, and the next step in your case would be a sentencing?
Yes, sir.
And did Mr. Armentrout go over this with you and explain everything to you before you signed it?
Yes, sir.
Do you feel that you had enough time to fully consider the matter before entering into the agreement?
Yes, sir.
And since it's been a few days since you signed it, is this what you still want to do today?
Yes, sir.
Now, the agreement states that, and you're entering into this plea voluntarily?
Yes.
All right. Now, the agreement states you're going to withdraw the not guilty plea and plead guilty to aggravated possession of methamphetamine under 2925.11 of the Higher Advised Code, a third-degree felony. Further states that you understand that the maximum prison term for that could be 36 months. The minimum is 9 months if a prison term is imposed. There's a fine available of up to $10,000. There's a possible license suspension between 6 months and 5 years. And for this purpose, the law says that there's a presumption a prison term should be imposed, but it is not mandatory, and the judges can grant community control instead. Do you understand that?
Yes, sir.
Now, other than this charge, Mr. Weil, are you facing any felony charges in any other jurisdiction?
No.
Are you currently on probation, community control, parole, or post-release control from any jurisdiction?
Yes, sir.
Now, under the law, should you be sentenced to prison in this case, once you complete that prison term, the law says that that the board, the adult parole authority, can, if they choose, put you under post-release control supervision for a period of up to 2 years, which means you'd be supervised by a parole officer in the terms they set, because the judge is not involved with that. If during that period of time they determine that you have failed to comply, they can return you to prison, even though you serve the entire term set by the court, for an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively the sentence in the new case. Do you understand that?
Yes, sir.
Now, as I said earlier, I'm not required to sentence you to prison for this offense. I can impose what's called community control, and that's what most people know to be probation. And that means that instead of going to prison, you'd be put under supervision of a probation officer on a term set by this court for a period of up to 5 years. Now, if during that period of time the probation department thought that you were not compliant, they would file a written notice of that with the court and serve a copy on you. There would be a hearing at which you'd be entitled to have an attorney. If the outcome of that hearing was that you'd failed to comply, then at that time the court could revoke your community control and then sentence you to prison for up to 36 months and fine you $10,000. Do you understand that?
Yes, sir.
All right, now, Mr. Wild, the charge in this case alleges that on or about April 27, 2022 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, an amount equal to or exceeding bulk amount, but less than 5 times bulk amount, in violation of Section 2925.11 of the Ohio Revised Code. So that's the charge of aggravated possession of methamphetamine with the penalties I just described. Now, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
Have you discussed the nature of the charge, the evidence in the case, the possible legal issues in the case, the possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes.
And are you satisfied with his advice and competence?
Yes, sir.
Are you under the influence of any types of drugs or alcohol?
No, sir.
Has anyone threatened you to make you plead guilty today?
No, sir.
Now, on page 2, there are 2 lines printed in bold and underlined that y'all read at this time. Defendant shall enter a plea of guilty to the indictment. State and defense jointly recommend community control, and defendant be referred to drug court. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No. No, sir.
Now, under the law, Mr. Wild, the matter of sentence is up to the judge, not the parties. And so even though there's an agreement that you should get community control or probation and be put in drug court docket, that is not binding on the court. I'll make that decision once I've heard all the information is presented. So, once that occurs, if I decide that's not the correct sentence, you could be sentenced to prison for up to 36 months. You could get a $10,000 fine. You could get a 5-year license suspension. You understand that?
Yes, sir.
Now, do you hold any license or certification from any state governmental agency that regulates any kind of occupation or profession?
No, sir.
Now, you have certain constitutional rights, you must understand, before I can accept a plea from you. First, you do have a right to counsel, and Mr. Armentrout was appointed to represent you. Now, that appointment wasn't simply to work the case out, but to provide any defense that could be available to you under the law that you would like him to provide. So, if you decide that you're not wanting to do this, he'll continue to represent you and defend you at trial if that's what you want. Do you understand?
Yes, sir.
Now, under the Constitution, you have a right to have a jury trial in this charge in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After 12 of those folks are selected, the evidence will be presented to them, and then the law would be given to them by the judge. And then that jury would decide by a unanimous verdict, meaning all 12 would have to agree, on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means to give up, your right to have a jury trial, and then in that case you would have what's called a court or bench trial. And in that situation, the judge would be the one who would hear the evidence, apply the law, and decide whether the state proved your guilt. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney and everyone else is present. After the prosecutor's done asking questions, your attorney will ask questions. That's cross-examination. And the purpose of that is to try to bring out evidence that might help your side of the case. Do you understand that?
Yes, sir.
Right, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify for you, just like the state. So, if you have witnesses you're not certain are going to come in voluntarily at your request, the court issues a court order, that's a subpoena, and that would force those people to come to court to be able to testify if you wanted them to, even though they didn't want to be here, which is the same way the state's witnesses are forced to come to testify against you. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence at any time in this case, including trial. So no one can ever make you testify. The prosecutor can't, the judge can't. It's up to you. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. And no one's even allowed to talk about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a right, you are presumed innocent until proven guilty by the state of Ohio in every essential element of the offense charged. So what that means is that the burden of proof isn't on you to try to prove you're not guilty of this offense. The burden is upon the state to prove that you are, and they must do that by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
Now, originally you entered a plea of not guilty. Not guilty plea denied the allegation against you, denied that you committed any crime, and it exercised or invoked all the rights I just described. If you change your plea from not guilty to the charge, that is the opposite of the not guilty plea. The guilty plea will admit the allegation, and the indictment admitted that it's a crime, that you committed that crime. And that plea will waive or give up all of the rights that I have described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But without exception, your plea of guilty would waive or give up your right to a jury or court trial, waive or give up your right to confront witnesses against you and to cross-examine through your attorney, waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify for you, the same as the state. It would waive or give up your privilege against self-incrimination, because if you say you're guilty, then the state doesn't have to prove you're guilty. And it waives or gives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal you think you may have had up until this point in the case. Now, should I sentence you to the maximum sentence or under certain circumstances, you can file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the charge and the possible penalties?
No, sir.
You understand them?
Yes, sir.
You have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
Do you have any questions about the constitutional rights that I've explained to you?
No, sir.
You understand those?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, and what the consequences of that will be if you enter it here today?
No, sir.
You understand that?
Yes, sir.
Now, is there anything you'd like to speak with Mr. Armentrout about before we go any further?
No, sir.
You have any questions at all about anything I've explained to you today?
No, sir.
Then is it your decision to go forward and enter a plea of guilty pursuant to the terms of the plea agreement that we've just gone over?
Yes, sir.
Right, then as to the charge, which alleges that on or about April 27, 2022, in Highland County, Ohio, that you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, an amount equal to or exceeding bulk amount, but less than 5 times bulk amount, in violation of Section 2925.11 of the Ohio Revised Code, a third-degree felony carrying a possible prison term between 9 and 36 months in the increments provided by law, a fine of up to $10,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty, sir.
All right, the court finds that on this day in open court, defendant was advised of all his constitutional rights, made a no intelligent voluntary waiver pursuant to Criminal 11. The defendant is found guilty of the charge as set forth in the indictment. The court will order a pre-sentence report to include assessment for substance use disorder and or mental health treatment. The case is referred to the drug court docket for consideration at sentencing. Bond will remain the same, and we will set the sentencing. April 5 at 9 a.m. All right. Is there anything further from counsel?
Only that, the court will consider releasing him on his own order. As I understand it, there was a bad man in tomorrow facility.
Okay. I'm not aware of that. What facility we're talking about? Miss Massey? Okay. All right. Well, will you send an email up to Marcia, and I'll have her go ahead. So I will order that your bond be modified to an OR without any additional surety under the same conditions that were ordered. But the additional condition is that you must remain at Massey House. If you leave, you have to come back to jail, and if you don't, then you violated your OR bond and committed another felony, and it's unlikely you're going to get community control if you do that.
Yes, sir.
All right. Thank you.
You can.
All right, are you Christopher Ernest Holt, appearing there from the jail?
I am.
All right, this is case number 22 CR 243, State of Ohio versus Christopher Ernest Holt. This hearing is being conducted by Zoom. Mr. Holt's attorney is William Armentrout, who's appearing from his office. Appearing from the prosecutor's office is Assistant Prosecutor King. Mr. Armentrout, you and your client both in agreement that this matter can be conducted remotely by Zoom rather than his appearance personally in front of the court.
Yes, Your Honor.
You're all right with that, Mr. Holt? You're waiving your attendance in the courtroom?
Yes, sir.
All right. Defendant is charged with aggravated possession of methamphetamine, a 5th-degree felony. Matter was set today for a plea hearing at the request of the parties. I believe a trial date is set for the 23rd. The court has received the plea of guilty form from parties. I'm going to hold this up to the camera so you can see it says you're going to plead guilty, Mr. Holt. Has your name, case number, plea of guilty, and the charge. Can you see that on the camera?
Yes, sir.
All right. And you recognize that form?
Yes, sir.
All right. It's a 3-page document. On page 3, about a quarter of the way down, there's a sentence that reads, "I enter this plea voluntarily." Below that, there's a line for signature of defendant. And I'll hold that up to the camera, and is that your signature right underneath that sentence I'm showing you?
Yes, Your Honor.
All right. When did you sign this agreement, Mr. Holt?
Yesterday.
And when you signed it, did you understand that it's an agreement to plead guilty, which means there's not going to be a trial, and the next step would be a sentencing hearing?
Yes, sir.
And did your attorney go over this with you and explain everything to you before you signed it?
Yes, sir.
And do you feel that you had enough time to fully consider this matter before making this decision?
I did, Your Honor.
And you're still wanting to go forward today with this agreement?
Yes, sir.
And you entered into the agreement to plead guilty voluntarily?
Yes, sir.
All right, now the agreement states that you're going to plead guilty to count 1, which is a single count in the indictment, aggravated possession of methamphetamine under 2925.11, a 5th-degree felony. Further states that you understand the maximum penalty for that offense will be between 6 and 12 months, and there's a fine of $2,500 available. There's a possible license suspension of 6 months to 5 years. You understand that?
Yes, sir.
Are you facing any felony charges anywhere else, Mr. Holt?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony?
Yes, I'm on parole in Clark County for my previous felony.
Is that post-release control?
Yes.
Okay. And you know how much, do we have that notification from the parole authority in the file, Mr. King?
I don't see anything in the file, Your Honor, and I was not aware that this suspension was even on PRC.
Okay. How long ago?
I contacted my parole officer and was telling him what was going on and about trying to go to treatment, and they were okay with it because they wanted me to do the same thing.
Okay. Well, the reason I bring it up, Mr. Holt, is that in the event that you're convicted of this offense, assuming that it occurred while you were on post-release control and not before, the date of this would have been June of last year. Yeah. Is that for the illegal manufacture case out of this court?
No.
Okay. Okay, you say it's out of what county?
That would have been Fayette County.
Fayette.
I'm on parole in Clark County.
Gotcha, okay. So, how long did you get on PRC?
Would have been 3 years. I'm supposed to get off in May if I complete treatment.
Okay. Well, under the law, if you are sentenced in this case and you're still on PRC, then the law provides that I could sentence you for committing this offense while under PRC in the other case to an additional period of a year, or whatever time is left on that period of post-release control, whichever is more. And so what that means is instead of just 12 months in this case, it could be 2 years or more, depending on how much time's left on the date that that sentencing would happen. Do you understand that?
I understand.
Okay. Now, as far as PRC is concerned, in this case, PRC is optional. And so if you are sentenced to prison at some time for this case, once you complete the prison term, the APA, Adult Parole Authority, as you know, could put you under post-release control for a period of up to 2 years. It's optional. They don't have to, but they could. If you are under PRC and you violate any of those conditions, as you know, they could return you to prison to make you serve an additional sanction of up to 9 months for one violation. But there is a cap or limit of half of whatever your prison term was. So in this case, the maximum is 12 months, so the most it could be would be 6 months. But if you committed a new felony while under post-release control, then in addition, whatever sentence could be imposed by the judge in that case, that judge could again sentence you for committing that offense while under post-release control in this case to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively, sentence in the new case. You understand that?
Yes, sir.
All right, now the charge alleges in this case, I'm sorry, now, under the law, I'm not required to sentence you to prison. And so I could put you under community control, which is what's recommended. If I do that, you'll be supervised by a probation officer under term set by the court for up to 5 years. If during that period of time the probation department finds that you have failed to, or feels that you have failed to comply, they will file a written notice of that with the court. There will be a hearing. You'll be entitled to have an attorney at that hearing. If the outcome of that hearing is that you have failed to comply, then at that time the court could revoke your community control and then sentence you to prison for a period of 12 months, fine you $2,500. Do you understand that?
Yes, sir.
Now the charge alleges that on or about June 11, 2022 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, in violation of Section 2925.11 of the revised code. So that's the charge. Now, do you understand, well, what it is you've been charged with by the state, what they said, when, where, and how they alleged you did it?
I do, sir.
And you understand the possible penalties?
Yes, sir.
Now, have you discussed this matter, the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, and possible outcomes of a trial with your attorney?
Yes, sir.
You're satisfied with his advice and competence in this matter?
I am, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you to make you plead guilty?
No, sir.
Now, on page 2, there's a couple of lines that are printed in bold that I'll read as follows. Defendant shall enter plea of guilty to the indictment. State defense jointly recommend community control, and defendant be referred to drug court. Is that your understanding of the agreement?
Yes, sir.
Anyone promise you anything other than that to get you to plead guilty?
No, sir.
Now, under the law, the matter of sentencing is up to the judge, not the parties. And so even though there's an agreement by both sides that you should get community control and be referred for possible admission into the drug court, that's not binding on the judge. And so if you plead guilty, once I've heard all the information, if I decide that's not the correct sentence, I could go ahead and sentence you to prison for 12 months plus whatever, either 1 year or whatever time's left on your PRC, whichever is greater, fine you $2,500, and suspend your license for a period of 6 months to 5 years. You understand that?
Yes, sir.
All right. Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, sir.
Now, you have constitutional rights you must understand before I can accept a plea from you. First, you have a right to have an attorney. Mr. Armentrout's been appointed to represent you. Now, that appointment wasn't simply to work the case out, but to provide any defense that might be available to you under the law that you would like him to provide. So, if you decide that you do not want to do this, that you'd rather defend against the charge, he'll continue to represent you and defend you at a trial if that's what you would like. Do you understand that?
Yes, sir.
Now, under the Constitution, excuse me, you do have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in this county that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented, and then they will be instructed on the law. And that, then that jury would decide by unanimous verdict, meaning all 12 would have to agree, on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up, your right to have a jury trial. And in that case, you would have what's called a court or bench trial. And that means that instead of a jury hearing the evidence, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court, testify in open court, in front of you, your attorney, anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
I do, sir.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state. So, if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order. It's called a subpoena, and that forces those witnesses to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. Do you understand that?
I do.
Now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's up to you. If you decide you're not going to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to talk about it with one exception, and that is if there's a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider that for any purpose. Do you understand that?
I do, Your Honor.
All right, now, under the Constitution, you're presumed innocent until proven guilty of this charge by proof beyond reasonable doubt on every essential element by the state of Ohio. What that means is that the burden of proof isn't on you to try to show you're not guilty simply because you've been accused. In fact, under the law, you're not required to present any defense at your trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. You understand that?
I do, sir.
Now, originally, Mr. Holt, you entered a plea of not guilty to the indictment, which denies the allegations, denied you committed any crime, and that plea exercises or invokes all the rights I've described. If you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. A guilty plea will admit the allegations, admit that they're a crime, that you committed the crime, and that plea waives, gives up all the rights I've described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. With that exception, your plea of guilty waives, gives up your right to have a jury or court trial. Waives, gives up your right to confront witnesses against you and to cross-examine them through your attorney. Waives, gives up your right to use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state. It waives, gives up your privilege against self-incrimination, because if you say you're guilty, that's what is used to find you guilty. It waives, gives up your presumption of innocence, because by saying you're guilty, you're giving up your right to require the state to prove you're guilty. Subjects you to being sentenced immediately by the court, if I decide that's the right thing to do. And finally, it waives, gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I sentence you the maximum sentence or under certain limited circumstances, you may be able to file an appeal. Any appeal you want to file would have to be filed within 30 days of your sentencing entry being filed. Do you understand that?
I do, sir.
And are you a U.S. citizen?
I am.
Now, do you have any questions about the charge or the possible penalties?
No, sir.
And you understand again that if you are sentenced to prison, the PRC time could be added.
I do.
Do you have any questions about the plea agreement?
No, sir.
You understand that?
I do.
Have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
I do, sir.
Have any questions about the plea of guilty, what it means, or what the consequences of that will be if you entered here today?
No, sir.
You understand that?
I do.
Now, is there anything you'd like to speak to your attorney about? Because I can put you and him into a breakout room where it'll just be you and him talking. No one else will see you or hear you if you need to talk to him. Do you have any matters you'd like to discuss with him at all?
No, I don't think so.
You have any? All right. Do you have any questions about anything I've explained?
No, sir.
All right, then, Mr. Holt, is it your decision to withdraw your not guilty plea and plead guilty to the charge pursuant to the terms of the plea agreement we've just gone over?
Yes, sir.
Then as to the charge, which alleges that on or about June 11, 2022 in Highland County, Ohio, that you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, violation of Section 2925.11 of the Ohio Revised Code, charge of aggravated possession of methamphetamine, carrying a fifth-degree felony, carrying a possible prison term between 6 and 12 months, plus 1 year, whatever time's left on your post-release control, whichever is greater, which would run consecutive. A fine of up to $2,500 and possible license suspension of 6 months to 5 years. How do you plead?
Guilty, sir.
All right, thank you. The court finds on this day in open court, the defendant was advised of all of his constitutional rights, made a knowing, intelligent, voluntary waiver pursuant to Criminal Rule 11. Pleas accepted and order filed. Defendants found guilty of the charge as of aggravated possession of methamphetamine, a fifth-degree felony as set forth in count 1. The court will order a pre-sentence report be prepared to include an assessment for substance use disorder and/or mental health issues and treatment. And sentencing will be conducted on April 5 at 9 a.m. And bond will be continued. Now, is there anything else from council?
No, Your Honor.
You've got no R bond in your case, so just whatever glitch your mind, because there's a bed available for him, I think, maybe tomorrow even.
He's on bond from this court, you say?
Yes.
Okay. Well, he's being held by who?
Enfield County Court.
Okay, well, they'll have to get the release from county court. If they agree, obviously in the OR bond, he can go there, so. Okay, thank you.
Thank you, Your Honor.